The webinar will begin in 1 minute. Welcome everyone. Thanks for joining us for today's webinar entitled The Secure Act, Part 2. The webinar will last approximately 45 minutes, and at the end, you will be given an opportunity to receive supporting materials by email. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Sujas. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning law practice in Franklin, Tennessee. Linus also writes the publication Think About It, founded by life insurance industry guru Steve Limeberg, and Linus regularly speaks at industry events. His latest book, Sell Out, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, that was written together with a CPA and a business broker, is now available for sale. Linus will draw on his legal, tax, and life insurance background and his practical experience for today's webinar. And here he is.
Thanks so much, Jennifer, and welcome to everybody on the call. This topic seems to be very popular right now. We talked last month about some of the provisions of the Secure Act, and we didn't talk about the new stretch provisions. We're going to talk about those today. There's a lot of detail there, and so I appreciate your indulgence on committing to, a kind of a long ride with us. I hope to be done in about 40 or 45 minutes, but we do have a lot of ground to cover. Before we get into that, I want to talk a little bit about what it is that we'll talk about next month, and I'd like to invite you to vote on what the topic might be for next month. We've got three choices: ethical issues with incapacitated clients. That's one choice. Dealing with terminal illness is the second choice. And then another choice that is very popular this time of year, Form 1099-R issues. We get a lot of calls about that. So that's the third choice on the list. So I guess I'd like to ask Jennifer to open the poll now and ask each of you to go ahead and cast your votes for what it is that you'd like to hear next month. I'll give you about 30 seconds to do that. Give you a couple more seconds. Most of you have voted, but for those that want to vote and haven't yet voted, please do so. Right now we have a tie, so somebody else needs to vote. The excitement is killing me. All right, so the poll, let's close the poll. We will talk next month about Form 1099-R issues. Thank you for voting. Thank you for casting your vote there. That's what we'll talk about next month. So let's go ahead and get on with part 2 of the Secure Act. And here's what we're going to talk about today. We're going to take a look at the old stretch rules because I don't think you can fully appreciate and understand what it is that the Secure Act has done to the stretch rules without at least knowing something about the old rules. That's one reason why we're going to review them. The second reason is that for those who died in calendar year 2019 or earlier, those that inherited those accounts still have to deal with the old rules. So it's important for both those reasons. We're going to take a look at the new stretch rules under Secure. That's the reason why most of you are on the call today. We'll quickly summarize the differences between old and new, and we will also spend a short time identifying some of the opportunities associated with the change in the law. Certainly there's an opportunity for Jennifer and for myself because we get a lot of questions about new law, and we're grateful for that. Although it makes it hard, I think, for those of us who work with clients to serve their clients well. And that's one of the things we're going to address today. So let's start with the review of the old stretch rules. So we'll talk about pre and post Secure Act stretch rules. And we'll start with the idea that the spouse was the beneficiary, and we're going to start with the idea that the death occurred prior to the required beginning date. So we had somebody who died in calendar year 2019 or earlier. The spouse was the beneficiary and death occurred prior to the required beginning date. So before we get started on the details here, let's talk about what the required beginning date is. You're going to see the idea of RBD, required beginning date, throughout this presentation. That's generally, under the old rules, April 1st of the year, calendar year following the year in which somebody turned 70 and a half. So got somebody who turned 70 and a half in 2019. The required beginning date is April 1st of 2020. That's the date in which, at which RMDs were due to begin from most qualified accounts. Now, for somebody who is still working, the required beginning date could be delayed until April 1st of the calendar year in which they stopped working, if it was later than age 70 and a half. But generally, the required beginning date, April 1st of the year, calendar year following the year in which somebody turned 70 and a half. So when we talk about required beginning date here, under the old rules, that's the date that we're talking about. So if we have spouse as the beneficiary of a qualified account, like an IRA, the spouse's choices were, first of all, to transform the account into the surviving spouse's own, either in place, if the plan administrator permitted it or the rules permitted it, or commonly by transfer or rollover into the surviving spouse's own plan, usually an IRA. So the inherited account went from the deceased spouse to the surviving spouse's own IRA, and that was one of the choices available. Could be another kind of plan, but a lot of times we're talking about an IRA. So that's choice number one, making the inherited account the surviving spouse's own. Or the spouse also had the ability to stretch the inherited account by taking annual minimum distributions based on the surviving spouse's age. And you'd use a period based on the single life expectancy of the surviving spouse. Now, I'm not going to go through an example of how that's calculated. I'll trust you to do it on your own, or if you're one of our customers, call in and we'll help walk you through that process about how the RMD is calculated. But minimum distributions would have to be taken beginning in the year after the decedent's death, beginning in the year that the deceased spouse would have turned 70 and a half. And so it's only surviving spouse's beneficiary where it's calculated this way. right? Where the RMDs begin with the year the decedent would have turned 70 and a half, and based on the single life expectancy of the surviving spouse. That's only surviving spouse where the beginning of minimum distributions under the old rules started at this time. So what happened when a spouse was the beneficiary under the old rules and death occurred after the required beginning date? Well, we also had the ability to transform the account into the surviving spouse's own, either in place if permitted or by rollover. Or you could stretch, and since the deceased spouse was already of RMD age, you'd stretch beginning with the year after the deceased spouse's death. The surviving spouse would stretch based on the deceased spouse's death. You know, I'd often get questions, I know Jennifer has too, why would somebody choose to treat the account as inherited as opposed to rolling it over into the surviving spouse's own account? And the answer has to do in part, in some cases, with product. Perhaps leaving it in place gave the surviving spouse a better performance rate, better interest rate than rolling it into a new account. Also, where the surviving spouse is younger than age 59 and a half, leaving the account as inherited allows the surviving spouse to avoid the penalty tax on pre-59 and a half distributions, whereas rolling it over into the surviving spouse's own IRA or own qualified plan means that the penalty tax potentially applies to distributions taken prior to the surviving spouse's age 59 and a half. So that's the reason why you might leave it as inherited as opposed to rolling it over into the surviving spouse's own account. So what about non-spouse beneficiaries? Well, for non-spouse beneficiaries where the death occurred prior to the required beginning date, under the old rules, there were two choices. The first choice was to liquidate the entire account prior to the end of the 5th year after the original owner's death, or to take minimum distributions based on the beneficiary's age and beginning with the year after the decedent's death. And that's different from the surviving spouse, who could wait until the year of the decedent's age 70 and a half. For a non-spouse beneficiary, if you're going to stretch based on life expectancy under the old rules, you had to start in the year after the account owner died. Now, some people talk about a third choice, and that's to simply cash out. For me, the third choice is a subset of the first choice, right? If you cash out now, you've liquidated prior to the end of the 5th year after the original owner's death. And so it's not really a distinct choice from my perspective. Cashing out is always a strategy. And by the way, if you choose that first choice, you don't have to take any distributions until the end of the 5th year after the original owner's death, but you've got to liquidate by that time. You've got to completely liquidate that time. And so you can avoid the immediate income tax hit, but you get a bigger income tax hit by liquidating prior to the end of the 5th year. So that those are the Pre-Secure Act rules for a non-spouse beneficiary where death occurred prior to the required beginning date. Well, what about if the death occurred after the required beginning date? Well, then the beneficiary's only stretch choice was to take minimum distributions beginning with the year after the decedent's death, right? So the beneficiary could always take more. So the beneficiary could decide to completely cash out and be done with it. That's all right. But beginning with the year after the decedent's death, the beneficiary has to take out minimum distributions based on the beneficiary's life expectancy. Now, it's also possible for the beneficiary to take out minimum distributions based on the decedent's remaining life expectancy if the decedent was younger. It's a little counterintuitive, I think, to talk about the life expectancy of somebody who died, but we're talking about a mechanical calculation based on tables, not what actually happened in real life. So If the decedent was younger, the life expectancy could make for smaller RMDs for a beneficiary. So that was really the only choice for a non-spouse beneficiary where the decedent died after the required beginning date. So those are somewhat straightforward, but a lot of times trusts are the beneficiaries of qualified accounts, and I often get questions from callers about why in the world would somebody name the trust the beneficiary of their qualified account, because it makes Stretch so much more complicated and sometimes cuts off some of the Stretch choices. And I have to kind of remind them that people do things for reasons other than taxes, other than the timing of income taxes on Stretch distributions. A lot of times they're looking for more control over their cash and other assets after their death because they're worried about their beneficiaries. And so that's often a primary motivation for naming a trust the beneficiary of a qualified account. In order to better understand the Stretch choices and better understand what the parameters are, I think it's important to cover a few things first. First of all, let's talk about the concept of look-through trusts. In general, if a trust is a look-through trust, you get to use the age of the oldest beneficiary of the trust to calculate RMDs. We'll talk about that in more details in a second, but the first question is, what is a look-through trust? Well, a look-through trust meets the following standards. First of all, the trust is valid under state law. Second, the trust is irrevocable or becomes irrevocable upon the death of the account owner. The third thing is the beneficiaries of the trust are all real people and are readily identifiable from the trust itself. And then a list of beneficiaries or a copy of the trust is provided to the qualified account administrator by October 31st of the year following the date of the grantor's death. If all of those boxes are ticked, then what we have is a look-through trust. And it's really important because look-through trusts get different minimum distribution rules than non-look-through trusts. You're also going to hear me talk about the concept of alter ego trusts. And this is really kind of my terminology here, but I think it's a pretty apt terminology. An alter ego trust is under the near exclusive control of a beneficiary, and that's a particularly important concept in the context of Stretch, because if it is the surviving spouse who is the alter ego of the trust, or vice versa, then there are special Stretch rules that are available, and we're going to talk about them in some detail in a second. Now, before we move on to describe the old rules where trusts are the beneficiaries, there is one more important thing that I want to say. First of all, you have to think of the trust where the trust is the beneficiary. You think of the trust as the beneficiary of the account. That is a distinct idea from who are the beneficiaries of the trust. A lot of times we will get callers who confuse the beneficiaries of the trust with the beneficiaries or beneficiary of the account. The trust is the beneficiary of the account, and it is the trustee who acts on behalf of the trust. The beneficiaries of the trust are a concern of the trustee, so that once the trustee gets the money under whatever Stretch rule is available to the trustee, once the trustee gets the money out of the account, the trust document tells the trustee who to send it to and when. So those are the beneficiaries of the trust. The distribution of inherited account money to the trustee of the trust isn't necessarily simultaneous with the trustee sending the money to the beneficiaries of the trust. So that's an idea that kind of has to be thought about and sorted out when you're dealing with a trust as a beneficiary of a qualified account. All right, you confused yet? Let's dig a little bit deeper. So let's talk first of all about the pre-Secure Act rules, the old rules, where trust was the beneficiary and that trust was the alter ego of the surviving spouse and also was a look-through trust. So the important point is that under those conditions, even though the trust was the beneficiary, the surviving spouse had the ability to transform the inherited portion to the surviving spouse's own IRA by 60-day rollover. So there are some private letter rulings that support this idea that the surviving spouse could roll over the money that she was entitled to from the account through the trust by taking a distribution from the trust and putting it into her own IRA or qualified plan account by 60-day rollover. That's an important thing. As I said, there are a few private letter rulings that support that idea. Now, what happened if the surviving spouse didn't do that? Well, the surviving spouse and other trust beneficiaries could take RMDs based on the age of the oldest trust beneficiary, using a period based on the single life expectancy of the oldest beneficiary determined the date after the death of the decedent, right? So it would be the trustee taking minimum distributions from the inherited account for the trust based on the date, based on the age of the oldest beneficiary of the trust, right? So in most cases, the first choice would be taken. In some cases, the second choice would. It is a choice. So what happens if we had a different kind of trust under the old rules? So let's say the trust was the beneficiary and it was a look-through trust, but not an alter ego of the surviving spouse. So if the decedent died prior to the required beginning date, then the 5-year liquidation option would be available. If the decedent died either before or after the required beginning date, stretch is available based on the age of the oldest trust beneficiary. Again, it is the trustee of the trust that is exercising this stretch choice, and distributions are made from the inherited account to the trustee of the trust. Again, it's based on the age of the oldest beneficiary of the trust, and they are annual distributions beginning in the year after the deceased account owner's death. So what happens if the estate was the beneficiary? Well, there's a special rule if the estate is under the exclusive control of the surviving spouse. Again, there is some private letter ruling support for the idea that the surviving spouse could take the inherited account and roll over distributions by 60-day rollover into her own IRAs, into her own IRA. If she didn't do that, then we have to ask whether the decedent died prior or after the required beginning date. If death occurred before the required beginning date, 5-year liquidation option was on the table. If death occurred after the required beginning date, then we've got the ability to stretch based on the life expectancy of the decedent, determined after the year of the decedent's death. Clear as mud yet? Well, let's move on. So again, we're talking about the old rules, and we've got a situation now where an estate or a trust was the beneficiary, and we've got no look-through or no exclusive and no exclusive control. And so the question is, before or after the required beginning date? If the death occurred before the required beginning date, the only stretch choice is 5-year liquidation. If after the required beginning date, then stretch based on the decedent's projected age in the year after death. That's it. One choice either way. If estate or trust was beneficiary, and if it's a trust, we don't have look through. If it's either one, these are not under the exclusive control of the surviving spouse. Wow. So those are the old rules. The good news is that for deaths that occur in 2020 or later, we don't have to keep those rules in our head for those new inherited accounts. The bad news is we've got to keep them in our heads because we're likely working with clients where they've inherited account and death occurred prior to then. So we do have to keep those rules in our heads. So in any event, let's talk about the new rules now and figure out what the differences are between the new rules and the old rules. So the first thing is that the Secure Act leaves inherited accounts that were inherited prior to this year, leaves them alone, except the old rule used to be that when somebody inherited an account and it was an inherited account and then that beneficiary died, the next beneficiary of the account could liquidate the inherited account as if the first beneficiary were still alive. They could finish the first beneficiary's stretch. That's changed. So for an account that was inherited prior to this year, when the first beneficiary dies, the initial beneficiary dies, the account's got to be liquidated by the new beneficiary by the end of the 10th year after the first beneficiary's death. So that's really the main change with regard to accounts inherited prior to this year. That's so 10-year liquidation on a subsequent beneficiary of an inherited account. So what's happened with regard to the beneficiary designations that we talked about earlier? So where the spouse was the beneficiary and death occurred prior to the required beginning date, these were the old rules. Now the new rule is, the only thing about the new rule that's changed post-Secure is if we leave the account as inherited, the date that the surviving spouse has to start RMDs is now the year in which the deceased spouse would have turned 72 as opposed to 70 and a half. So that's the only difference, the date in which the surviving spouse has to start RMDs for an account that has kept its character as inherited. So what about where spouse's beneficiary and death occurs after the required beginning date? Well, there's good news. There is no change from the pre-Secure Act rule. The spouse still has the same choices. What about a non-spouse beneficiary? Well, if we've got a situation where we do not have an eligible designated beneficiary, and we'll talk about who those are in a few minutes, where we've got a non-spouse regular beneficiary, death occurs prior to the required beginning date, then the only stretch choice for that beneficiary is to liquidate the inherited account prior to the end of the 10th year after the original owner's death. So stretch based on lifetime, which was available under the old rules, is not available under the new rules. It's the biggest change that we need to be aware of. What about where non-spouse is the beneficiary and death occurs after the required beginning date? It is the same rule as death prior to the required beginning date, which is the beneficiary must liquidate the entire inherited account prior to the end of the 10th year after the original owner's death. Again, it's a change. In ways it makes things easier for us because there are fewer choices for most of the non-spouse beneficiaries that we're going to be working with. but it makes it a little tougher on them from an income tax perspective because they don't have the ability to stretch out the income tax result over as long a period as was potentially available to them under the old rules. So there's stuff for us to talk about with them about that. So those compared nicely with the old rules. Those were pretty straightforward, but as with most new legislation, Congress and the president didn't think of everything and didn't necessarily cover things in the detail that we would like. So there's a lot to talk about. First of all, with the idea of eligible designated beneficiaries, EDBs, but also with regard to trust beneficiaries of qualified accounts under the new Secure Act rules. So let's first talk about the idea of eligible designated beneficiaries, EDBs. So first question is, who is an EDB? Well, you'll see that I don't have surviving spouse on the list. Technically, surviving spouse is an eligible designated beneficiary, but we dealt with the surviving spouse separately already, and so I'm not going to include surviving spouse on the list of eligible designated beneficiaries, even though under the Act, surviving spouse is an eligible designated beneficiary. What I am going to talk about is, first of all, minor children of the account owner. Minor children of the account owner are eligible designated beneficiaries. And it's not just minors. It must be a minor child of the account owner. They've got special stretch rules. We'll talk about what those are in a second. If a beneficiary is disabled or chronically ill, then we've got a special stretch rule with regard to disabled or chronically ill individuals. And then the third category that we're going to talk about is a named individual who is no more than 10 years younger than the deceased account owner. So all three of those are eligible designated beneficiaries, EDBs, that we're going to talk about in the context of stretch. So let's talk about a non-spouse being the individual beneficiary before or after the required date for the decedent. So if we've got a minor child of the account owner, we've got the ability to stretch by taking minimum distributions based on the minor's age, using the single life expectancy table, beginning with the year after the death of the decedent. So the minor gets to stretch based on the minor's age, and the minor would have minimum distribution requirements. That option is available until the minor hits the age of majority. And it would be a reasonable question for you to ask at this point, what is the age of majority? And the Secure Act doesn't tell us. We're assuming that that's age of majority under state law, but we'll see. They may give us a hard and fast age of majority in any regulations that come out later. We don't know. Once the minor hits the age of majority, there's a 10-year liquidation requirement from that year forward, right? So 10 years after the minor hits the age of majority, the account must be liquidated. The inherited account must be liquidated. So that's the rule with regard to a minor beneficiary. So let's talk about somebody who's disabled or chronically ill. If a beneficiary is disabled or chronically ill, we've got the ability to stretch based on life expectancy, just like we could for a minor. We're going to use the beneficiary's life expectancy using the single life table until the chronic illness or disability impairment is removed, right? For some people for people who are chronically ill or disabled forever, I mean, the stretch could last, as long as they live. Once the impairment is removed, either because they get well or because they pass away, then the entire inherited account has to be liquidated within 10 years of that occurring. And let's talk finally about somebody who's no more than 10 years younger than the decedent. Somebody who is of that age can take RMDs based on the beneficiary's age or the decedent's age if the decedent was younger, using the life expectancy formula. And that's it. They get to stretch based on age. So things get really dicey and much less clear where we've got a trust as beneficiary under the Secure Act rules. Let's start with the easiest situation where we've got a surviving spouse is basically the alter ego of the trust. So the situation is where it's look through and surviving spouse is alter ego, then we've got the ability to roll into the surviving spouse's own IRA or own qualified plan by 60-day rollover. So that's the same as it was under the old rules. If the surviving spouse doesn't do that and the trust simply remains the beneficiary of the account, because it's a look-through trust, we've got a 10-year liquidation after the original owner's death. That's the other stretch choice. Well, what about if we've got a different situation? Let's say we've got look-through and no eligible designated beneficiaries. Well, because the trust is look-through, we believe that the only stretch choice is to liquidate prior to the end of the 10th year after the original owner's death. Doesn't matter when the date of death occurred, before or after the required beginning date. The only stretch choice is 10-year liquidation. What about where we've got look-through with one or more eligible designated beneficiaries? And I said we left surviving spouse off the list of eligible designated beneficiaries earlier. Here we're putting surviving spouse back on. We've got a look-through trust. Surviving spouse is one of, perhaps the only or one of the eligible designated beneficiaries. With regard to the surviving spouse's portion, if the trust allows for it, the trustee could make a distribution to the surviving spouse, and the surviving spouse within 60 days could roll that over into her own IRA. We think that that's available. We would tell you not to go make a marketing program out of this because it's early. We think this should be available, but it shouldn't be attempted unless the client's own tax advisors are signed on to the process. The other stretch choice is, because this would be a look-through trust, we've got 10-year liquidation by the trustee of the inherited qualified account. That would be the other choice. So what about other types of eligible designated beneficiaries? Let's say that it's a minor child. Again, we're making some guesses, but the conservative position is that stretch must be based on the age of the oldest beneficiary of the trust, because all we have is the look-through rules that we had prior to Secure Act. And that means that if all of the beneficiaries of the trust are minors, stretch is possible by the trustee only until the oldest minor reaches the age of majority, at which point the trustee must liquidate the inherited account by the end of the 10th year after the first minor comes of age. Then the second observation is, if the trust has both minor and adult beneficiaries, 10-year liquidation is probably the only option. Now, it may be that we'll get regulations that are more favorable than this, but this is our best guess, our best conservative guess, based on the way that the rules read today. What about a disabled or chronically ill individual if they're the beneficiary of a trust and the trust is look through? Um, the Secure Act is actually a little bit more specific about what might be available under these circumstances. The Secure Act specifically says if the trust can be split up so that there's a portion exclusively designated for a disabled or chronically ill person, then that portion can be stretched until the impairment's removed, either by death or because the person got better. Then 10-year liquidation after that point. If the trust cannot be split, then you're stuck with 10-year liquidation, or the trustee is stuck with 10-year liquidation of the inherited account. We'll look for some more regulations on this, but that idea of splitting out the trust so that a portion can be used exclusively for a disabled or chronically ill person is kind of baked in. And so we feel pretty good about that part of it. And so where you're working with somebody who is thinking about leaving part of a qualified account to somebody who is disabled or chronically ill, putting some mechanism in the trust so that the portion can be exclusively allocated for the disabled or chronically ill person is going to be important, particularly as we go forward. So what happens where we've got a beneficiary who's no more than 10 years younger than the decedent? It's again uncertain. We're wondering whether the trust can be split up so that the portion of the trust is available exclusively for the beneficiary no more than 10 years younger than the decedent, can be split from the other beneficiaries. If it can, perhaps minimum distributions based on that beneficiary's life expectancy may be possible, but we're waiting for regulations. And for sure, if you've got this situation where a trust is the beneficiary and you've got a mixed bag of trust beneficiaries, some of whom are within 10 years of the decedent's age and others who are not, who are much younger, then you better, before you commit to a path, you better get the client's own tax advisors to be signed on. Presumably before we make a final commitment there, we'll have some regulations, but we don't always get regulations in the time frame that we're hoping for. So there you go. What happens where we've got an estate that is the beneficiary that is under the exclusive control of the surviving spouse? Well, just like under the old rules, we believe that a 60-day rollover into the spouse's own IRA or qualified plan of the inherited account is possible. But if an estate is the beneficiary and the surviving spouse doesn't take advantage of that, we're stuck with 5-year liquidation if death occurred prior to the required beginning date, or continuing the decedent's RMDs if the owner died after the required beginning date and the estate is the beneficiary. What about a situation where we don't have a look-through trust? We've got a regular trust, a non-look-through trust, where we've got an estate as the beneficiary, not under the exclusive control of the surviving spouse. Well, then we're stuck with either 5-year liquidation if death occurred prior to the required beginning date, or continue the decedent's RMDs if the owner died after the required beginning date. Wow. That's a lot to try to keep straight in your own mind. I guess the observation I'd make to you is learn as much as you can about this. I recognize that if you didn't feel like your knowledge about this was close to perfect before you got on today's call, feel welcome to re-watch what it is that we've done. We'll send a link to folks who are attendees today after the webinar. rewatch it, and learn as much as you can from other sources, because this is pretty heavy duty stuff for folks to get their minds around. It's hard for financial professionals and lawyers and accountants to get their minds around it, and probably nearly impossible for a layperson to understand this stuff. But if we've got the ability to explain what is going to happen in a specific situation, that's really how we can probably best serve our clients. So let's talk about, in summary, what the differences are, the main differences are between the old rules and the new rules. First of all, surviving spouse beneficiary. Surviving spouse is technically an eligible designated beneficiary under the new rules, but the surviving spouse beneficiary has similar stretch choices under the old rules and the new rules. There really isn't that much different, and so that's good news for our surviving spouse clients. It's easy. It's relatively easy to understand what choices are available. The other observation is that now most non-spouse beneficiaries have only a 10-year liquidation option. They don't have the ability to do a lifetime stretch like they could under the old rules. Trust and estate beneficiaries, where the surviving spouse is in control, has similar choices under the old and new rules. Most look-through trusts, we're guessing, now have a 10-year liquidation requirement. Used to be able to stretch based on the age of the oldest beneficiary. Now, the trustee of the trust must liquidate the inherited account for most situations by the end of the 10th year after the original account owner's death. Individual named eligible designated beneficiaries have the ability to stretch based on life expectancy, at least for a while, for minors until they come of age, for chronically ill and disabled people until they pass. For named individuals who are no more than 10 years younger than the deceased account owner, they've got the ability to stretch now based on life expectancy like they had under the old rules. And we've got a lot of unanswered questions with regard to trusts as beneficiaries, particularly if ineligible designated beneficiaries, one or more eligible designated beneficiaries, are beneficiaries of a trust that is the beneficiary of an inherited account. And we're going to have to wait for regulations to get final answers on a lot of those situations. So what are the opportunities for us, for those of us who work in this market as we move forward? Well, as with anything else, we've certainly got the opportunity to go talk to clients about what has changed. In the meantime, we're going to be carrying around two sets of pretty complex rules about stretch as we're working with our clients who have inherited interests in qualified accounts. We have to keep in mind that there are two sets of complex rules. Don't necessarily have to know all the details, but we're going to have to know something about when the account was inherited and who has inherited it for us to be able to go back and do a little research to be able to answer the questions that our clients are going to have about stretch. We do have the ability to talk to our existing clients about stretch. We're probably going to have to engage in conversation with them about whether the beneficiary designations that they've made in the past still make sense as we're going forward. And we're certainly going to have to explain to them the consequences of the beneficiary choices that they've made with regard to stretch. For prospects, I think it's an extra reason to invite them to go through a beneficiary review, which I think has always been a great way to start a professional relationship. If you go and you're meeting with somebody and you say to them, look, I have found that the beneficiary designations for a lot of people that I meet with are wrong and don't match up with what they have in mind. Would you let me review those beneficiary designations with you and check to see if yours are okay? I think that's a great way to start a relationship. And you're going to find opportunities to serve those folks. Even if you don't sell them anything, you're going to find opportunities to serve those folks, even if the only thing you tell them is, look, you're good with regard to your beneficiary designation. This matches up with what it is that you have in mind. So I know that was a lot. Thank you for hanging with us today. We talked about the old rules, the old stretch rules before Secure Act. We talked about the new rules post Secure Act. We recognize that you may have questions. Feel welcome to email them to us after the meeting, and I'd invite you to rewatch the video recording of today's session if you feel like some things weren't particularly clear to you, or contact us if we can help clarify things. And at this point, I'd like to turn the program back over to Jennifer to close us out.
Thanks, Linus. And thanks for joining us for today's webinar. And don't forget to register for next month's webinar. As a reminder, if you would like to receive supporting materials or ask questions related to today's webinar, feel welcome to email me at asktheexpert@advancedunderwriting.com. Again, that's asktheexpert@advancedunderwriting.com. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact me at 615-224-1291. Again, that's 615-224-1291. Thanks again, and best wishes for continued success.